What can business owners do to prevent employees from taking client lists and other confidential information in the company to either a competitor or to start their own business? First, we have the Trade Secrets Act. There's a federal Trade Secrets Act, and then most states have a state Trade Secrets Act. That law says if the business makes reasonable efforts to keep certain information a secret, we'll call them trade secrets, it is a violation of that statute for an employee to use that information for any other purpose than the company's goals. So if the employee downloads a copy a week before the employee leaves, and then the employee takes it to a competitor or opens a new business, you can sue for violation of the Trade Secrets Act. You can also probably sue for violation of the fiduciary duty of loyalty. Most states have built into their common law, which means even though there's no statute, the courts follow this general rule that employees have a duty of loyalty to their employer, and they can't act in violation of that duty of loyalty to hurt the employer. So there's probably a breach of a fiduciary duty of loyalty claim there. Now, it is important in order for employers to enforce that law that they make reasonable efforts to keep that information confidential. So if the employer has a brochure that they provide to customers, that's not confidential information. That's not considered a trade secret. It actually has to be a secret that the employer reasonably keeps confidential. So if an employee leaves and then they copy the employer's website, that's not necessarily a breach of fiduciary duty or a breach of the trade secret law. Might be a violation of copyright law. There's one other thing that you can do in some states, I'd say in most states. If employers ask an employee to sign a non-solicitation agreement at the time the employer offers the employee a job, then the employer can sue the ex-employee for breach of that non-solicitation agreement if the employee goes off and starts soliciting or basically breaching the agreement. So here's how that works. The employer in most states has to say, hey, I'm offering you this job. Like, let's say, for example, the employer wants to hire a salesperson, and the employer wants to hand over some really big accounts to that salesperson. So I'll make a hypothetical here. The employer is a branding agency, and their clients are Pepsi and Apple Computer, and they want to hand those relationships off to an account manager. So that when hiring an account manager, they ask that person to sign a non-solicitation agreement, which basically says, if you ever leave our company or we fire you, you can't take Pepsi and you can't take these big companies with you. That is another way to prevent employees from taking customers with. But there's a catch. Those contracts are illegal in some states like Minnesota and California. They simply won't be enforceable. So that's a quick overview of some of the ways that you can protect yourself as an employer when hiring employees.